Dario, maybe let's just start in the beginning where we just understand the history and the background behind the Protection of Personal Information Act. Where does it stem from?
The legislation is in fact legislation that comes from the constitutional right to privacy, which of course has been around in a constitutional form since our 1993 constitution, then our 1996 constitution. The act itself that has now been put into force, subject to the 1-year housekeeping period, is in fact a 2013 act. So it's been on our statute books already for some time.
And why would we need a law like POPIA?
You need a law like POPIA simply because we have a right to privacy in the Constitution, which needs to be given effect to, and you need practical ways to enforce that right. The right to privacy is a human right, it's a fundamental right. It means that we have a right to determine the destiny, ultimately, of our personal information. Mm-hmm. The history behind it is the need for our constitutional right to privacy to be given teeth, because the common law of privacy is very vanilla type of protection for citizens. So it's expensive, there's an access to justice problem, and thirdly, the damages that you get for showing that your privacy has been infringed are so nominal as to make the exercise completely worthless when you look at legal fees and the time that it takes for your case to wind its way through the legal system. So there was clearly a need for comprehensive, effective legislation that protects citizens' rights to privacy. And that's essentially what POPIA does. Although we have protection under common law for that, there's no doubt that the POPIA Act is radical privacy-based legislation, because it's there to say to public bodies and to private bodies, whether you've got employees, whether you've got suppliers, customers, pretty much from a large to a small organization, a public body or a private body, whoever you are, you have to take privacy seriously. The privacy of your, what we call data subjects, which is the people who you hold information about. And the legislation is there to ensure that if you believe your privacy has been infringed, your personal information has been used, processed in a way that goes against POPIA, you have the right to go to the information regulator and make a complaint. You don't have to go to court, which is your only option at the moment.
In the advent of big data, artificial intelligence, data mining and that sort of thing, how appropriate and how relevant is this POPIA Act in this moment in time?
Well, I think it's absolutely critical with the digital revolution that POPIA was put into force. There's absolutely no doubt that without POPIA, for example, data breaches are frequently swept under the carpet, and companies who are the unlucky victims of data breaches frequently hope that the fact of the data breach never comes out. Under POPIA, there's a radical change in that, because you have to inform the data subjects that their information has been compromised. We may well have all been victims of massive data breaches by South African public or private bodies, which we don't know about, because there was never a duty to tell us. There was never a duty, if you like, to blow the whistle on yourself. POPIA now creates that obligation. You have a duty to inform not just the data subject, but you also have a duty to inform the information regulator, so the government body that is now set up to police this. So there are a lot of very, very good reasons why the notification requirement is there, and it is best practice around the world to notify your data subjects, those who you hold information about, that there has been a breach. And then further, you have to notify, as I say, the regulator. You have to notify the regulator because the regulator polices all of this. And, capacity constraints aside, what the regulator wants to do is it wants to ensure, first of all, that you are taking steps to mitigate this breach. We have companies who operate as really serial processors of information. There are companies who process millions of items of information about individuals, insurance companies, banks, etc. And the information regulator is there to say, not just in the small breaches, but also with the big breaches, we are here to ensure that the right steps are being taken so that you've mitigated any further harm to individuals. and of course also because the information regulator can itself take legal action against you as the company if you have caused a data breach irresponsibly.
How does our South African POPIA Act compare with the EU's GDPR law? And how much stronger is it in terms of protecting people's information and data?
In one way, we were lucky that it took so long for our data protection laws, our POPIA Act, to wind its way through Parliament and ultimately be signed into force, because we were able then to witness and digest what was going on around the world in terms of developments in data protection law, such as in Europe, the GDPR. And fortunately, most of that learning, for instance, the right to be forgotten or de-indexed from a social media site, finds its way into the POPIA conditions and the principles and the obligations in POPIA. So there's a great degree of harmony between POPIA and the GDPR, which is the newish European data protection law. In one respect, we go further than many other countries. Our law that is now in force applies not only to individuals like us, but also to companies. So although it's the Protection of Personal Information Act, it's an act that not only protects individuals, but it also protects juristic persons where applicable. And that means companies' information, companies' personal information is also protected. But ultimately, the incentive to comply by public bodies and by private bodies is not so much that the regulator will come knocking and will fine them 10 million rand, which is one of the possibilities under the legislation, or that they might face a criminal offense, a criminal charge one day. Ultimately, the incentive to comply will be reputational, because if you are accused of being cavalier, of playing fast and loose with your data subjects' information, your customers' information, your employees' information, that is ultimately a trust issue between you and your stakeholders. Facebook Cambridge Analytica scandal is a very high-profile example. So, in my experience, what companies will want to do is they'll want to avoid that reputational consequence. But actually, POPIA should be seen, in my view, by companies and by public bodies as an opportunity to showcase the fact that they take citizens' privacy seriously. This piece of legislation shouldn't be seen as just another piece of legislation that I must comply with now as an employer or as a public body. It should really be seen as the right thing to do in terms of the right to privacy. And for the first time in South Africa, it is empowering citizens to say, if you are not treating my information seriously and you're not taking reasonable steps to protect my information, I can go to the regulator. I can ensure that not just will you suffer legal consequences, but there will also be reputational harm.
There's also some new parts of POPIA that came into effect, and that was as of the 1st of July this year. What are some of those parts, and what do they mean for organizations and individuals?
So here's the thing. POPIA is onerous legislation. It contains 8 very, very strict conditions. It contains restrictions on when you can do direct marketing to the general public and to your own customers. It contains restrictions on when you can transfer people's information cross-border. There are special rules with children and processing their information, and also processing a certain category of very sensitive information called special personal information, like a person's health information. So it's very onerous legislation. So what happens is that since July, the legislation says you've got a year, which is effectively a year to get your house in order. And the reason you've got that, which is in some ways quite unusual, to say we're passing a law, but we're giving you a year before it actually kicks in, or it actually bites. The reason for that is that there's so much to do if you haven't started thinking about compliance with POPIA. Then you better start now. Even if you are a small enterprise, a medium-sized enterprise, and certainly if you're a large organization, a year is not a long time. to get your house in order, because you've got to ensure, first of all, that you know what information you are processing about your customers, your employees. And then you need to know why you're processing that information. Is it because the person was an employee 20 years ago? And if so, do you still need that information? Do you have consent to keep that information? How should you destroy that information? There are lots of very, very critical questions that have to be answered in an analysis of, how compliant am I with POPIA? So that's why there's this breathing space of a year. No consequences can flow in the first year.
One of the things that you alluded to earlier on, it's something that you spoke about, and you said that, by law, now companies have to disclose if there was a data breach. And my question is, why is that so important, and how do we make sure that companies do this?
Yeah, it's critical from a transparency point of view that data breaches be notified, both to the data subject and to the regulator. Why to the data subject? Because you're then saying to someone, first of all, it's good business practice. You're saying, you are my customer, you're my employee. I'm sorry to tell you there's been a data breach, but here's what we're doing about it. Here's why it happened, and here's why we're going to fix it. So that's important just from a retaining trust perspective. It's also important because you allow data subjects to decide, once they know that a breach has happened, what action do they take? If it's a security bank account security issue, for example, it might mean that they must change passwords, etc. So you are empowering them to take steps to protect their own information. You also are allowing them to consider their legal options. If they don't know that there's been a breach of privacy, they don't know that they might have a right to compensation for the any patrimonial harm or any non-patrimonial harm that they might suffer as a result of that breach. And that, as I say, links in with access to justice, empowering the consumer because they know what's happened with their information.
I'm sitting at home, my phone rings, and somebody phones me from an insurance company or a life policy company and says to me, "Hi, Mr. Mledi, we'd like to offer you such and such a product." Do I immediately say to you, "Where did you get my information from? How did you get my information, and what you're doing is illegal"? Can I, at this point in time, do that? And would they be breaching the POPIA Act?
Direct marketing, which is where we all get unsolicited communications, phone calls, emails, etc., that sometimes don't go into our junk mail folders, that's soon going to be a thing of the past, in the sense that POPIA says, POPIA says quite explicitly that you can't market directly to any person who hasn't given you the consent. So it's an opt-in type of process. And that means you can approach them for the consent, because of course you don't know they've consented until you've done so. So I can phone you and say, "McFarlane, I've got a great new insurance product. I'd like to send you information about it. Can I send you all my newsletters and my leaflets?" If you say no, you're opting out, and I can't do that again. You can only approach a customer once to try and get their consent. POPIA says you can't sell my information. You can't give my information to other parties, to other companies, just because they pay you a fee for that. You can only do that with the consent of the data subject, or if you've complied with the other provisions of POPIA. When we talk about empowering the consumer, what we're talking about is using their information in a way that they have consented to, or in a way that is otherwise lawful in terms of the Act. They're saying, "We've asked you, you've consented, storing it securely and all the other conditions of POPIA, but we can't do that effectively in a way that harms your right to privacy."